Alan Spector here, and every Tuesday and Thursday morning at this time, we bring you Olson on Law with longtime Orlando attorney Tom Olson. Good morning, Tom.
Good morning, Alan and crew and WFLA listeners.
Tom, here's our topic: removing a spouse's name from a deed when he or she dies. So do most married couples have both of their names on a deed to their home?
That's usually the case. Both of their names are on a deed, followed by the words "a married couple." But married couples are often surprised to learn that only one of their names is on the deed to their home. And if that's the case, I recommend that they do a deed adding both of their names to the deed to the home.
As you've told us before, everyone wants to avoid probate, Tom. If both spouses have their names on the deed, will probate be required when one of them passes away?
The good news is no. All that needs to be done is record the deceased spouse's name in the public records. No new deed is needed. The old deed, together with the death certificate, places a title in the surviving spouse's name.
Now, speaking of that death certificate, will the funeral home record that death certificate for you?
The funeral home will order your death certificates, but they will not record it for you. It's up to you to do that.
Okay. Anything else the surviving spouse needs to do, Tom?
Yeah, if your spouse has passed away, you can apply for an additional real estate tax exemption called a widow's exemption. That will save you an additional $500 a year on real estate taxes.
All right. If you have legal questions about this or anything else, Tom would love to answer those questions on the Olson on Law show. That is heard Saturdays at 10 a.m. here on News Radio WFLA Orlando. Remember, you can catch the Zoom version of Tom and me, see what we look like. Yikes, on our social media platforms. Tom, thanks very much. We'll see you next time.
Thank you, Alan.
And remember, for all of your legal needs, call the Olson Law Group in Orlando.